Storman. Mr. Storman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Storman.
Welcome to Lawline. The call for tort reform has been heard loud and clear on a national and local level. Today we'll see what constitutes negligence and what effect limitations on lawsuits and cap on awards will have on the victim. Our guests are Robert Lamb, President of the New York State Trial Lawyers Association, and Harold Jacobowitz, Vice President of American International Company, an international insurance company that deals with accident cases worldwide. Hello, Bob. Hello, Harold.
Hello.
Bob, what is the current situation now? We have politicians who are falling off platforms and saying, 3 lawyers called me. We hear people talking about tort reform and politicians saying that they're going to change the system. What's your opinion on what's happening?
It's a great soundbite, tort reform, isn't it? Everybody's in favor of tort reform, but nobody knows what tort reform is. In my opinion, the civil justice system is the greatest engine for justice in this country that we've ever seen. The civil justice system is a system for change. We protect people, we protect victims, and we get recoveries for people who deserve recoveries. That's what it's about. Tort reform, just for the sake of tort reform, is nonsensical. It's a great platform for a politician to run on, but it's not as sensical or makes no sense at all.
Harold, I know you're Vice President of American International Companies. I recently saw an advertisement, a full-page advertisement in one of the newspapers where your company discusses changing the tort system. What's your opinion on that?
Our opinion is actually, it's interesting. No one is attacking the civil justice system per se. The simple fact of the matter is there are some problems with the system that need fine-tuning. There are some excesses involved in the way the system is working these days that need some fine-tuning. But the civil justice system per se is not under attack. The simple fact of the matter is there are some issues that have to be dealt with in the way civil justice is dispensed in this country.
Would you say that closing down courthouses and eliminating the right for a person to go into a courthouse is fine-tuning? That's what the proposition
first of all, I don't know that anyone's calling to close down courthouses or eliminating anyone's right to get to a jury or to the courthouse. Simple fact of the matter is there are certainly circumstances where based on either the nature of the lawsuit, the award of the lawsuit, the time it is taken to resolve that lawsuit, the way that lawsuit has been prosecuted, have certainly been, at a minimum, an abuse of the system.
Well, Harold, when you start talking about loser pays, that seems to me to be a chilling effect, and people who cannot afford to pay the high price that AIG pays for their lawyers certainly are denied access to justice. That's not a system that is, in my opinion, equal justice, and I think it's an issue, it's a constitutional issue, equal justice under the law. And when you start talking about loser pays and you start talking about sanctions and things like that, you are denying due process, and you're denying people who don't have $1 million the opportunity to fairly and adequately prosecute their grievances.
Well, you know, the interesting aspect of all those who argue against loser pays, and whether or not we can get into the merits and relative demerits of loser pays.
We're talking about loser pays. Whoever loses a lawsuit pays the litigation expenses. Is that what we're talking about?
But you know, let's look at the root cause or the problem that loser pays is attempting to resolve, and that is there is no question but that there is a significant amount of frivolous litigation in this country that is a burden on this country in general and the defendants who are sued in that frivolous litigation. The simple response is, of course, to say that this one remedy is no good and therefore there is no solution. The interesting thing is those who attack loser pays never proffer an alternative, never even recognize the fact that there is a problem with frivolous litigation.
Frivolous lawsuits, that's an interesting question. Frivolous lawsuits. I've heard for the past 20 years that there are frivolous lawsuits. Every damn insurance carrier in this country talks about frivolous lawsuits. Every manufacturer talks about frivolous lawsuits. Let's shift the focus for a second. What about the frivolous lawsuits that the manufacturers in this country, that the insurance carriers in this country have going on in the court systems of the country right now? 57%, that's my understanding, but my last read was 57% of the lawsuits that are going on in this country at this time are between corporation v. corporation, corporation v. carrier, et cetera, et cetera, et cetera. Something like 15% of the lawsuits that are going on in this country today happen to be tort cases, medical negligence, automobile, et cetera, all of the whole panoply of negligence cases that we've got going on. But let's talk about, for a second, what about the frivolous lawsuits that the various corporations bring about? We don't hear the manufacturers or the carriers talking about that. That seems to be okay. But frivolous lawsuits as to victims now occupies page 1. A jury tells us whether this is a frivolous lawsuit, and they tell us by delivering a clear message, and that clear message is no cause for action. We don't agree with you, this grievance, and you are
Harold,
not...
But that doesn't eliminate the fact that the defendant brought into that frivolous lawsuit has expended much time, money, and effort, and gets nothing in return for that no cause for action.
Let me bring you back. Let me bring you back.
The process of litigation
Let me
and
bring
the
you...
burden that imposes on the defendant involved in the frivolous suit is not recompensed.
Let's just bring back 1 second. If you had the ability to reform the system, what would you recommend? What is it your company wants to do to change the system, whether it's to eliminate what you consider frivolous? What is it your position?
No,
I want to ask what frivolous is. What is frivolous?
A lawsuit that lacks merit, clearly and unequivocally.
So should the defense have should the plaintiff have the right to go and say, let's get rid of the frivolous defenses? I get an answer in my office, and it says lack of jurisdiction, yet I send an affidavit. What about frivolous
Harold, what is
defenses?
it
Can
that
we
you-
eliminate
I'm
that?
opposed to frivolousness on wherever it occurs.
Harold, tell me, what is it that you would propose to change the system that you would feel would enhance the system?
There are a number of things. First of all, you first have to understand what we see as part of the problem. Part of the problem with tort litigation in this country, as it presently exists, is it takes too long, it costs too much, and the results are too unpredictable. So, what the simple answer to your response is, we're open to any solutions that attack those three issues. And the simple fact of the matter is, there are a number of things you can do in a whole host of areas that would help affect those things. One way of dealing with it is, of course, alternative dispute resolution. That is something that can shorten the duration of suits as well as...
Take the suit out of the
expense.
courthouse, take the adversary proceeding out of the courthouse and put it somewhere else. Take it away from the jury?
No, one way is taking it out of the courthouse or having it as an adjunct to the courthouse, as an alternative
What else?
method for
In all due
resolution.
What else?
respect, that's being done today.
Well,
Alternative
it's being
dispute
done to- it's
resolution,
being done to a
but you
degree.
need to have agreement on both sides. You can't say to somebody, you're losing your right to take your lawsuit before a jury of your peers. I mean, let me take you back. Let me take you. Wait, let me take you back. Wait a second. Wait a second. Wait a second. Wait a second.
I argued against the jury system per se in connection with tort reform. No, I haven't heard anyone argue that we should eliminate juries from
What
the
about
American
caps
civil
on
justice
awards
system.
for pain and suffering? What's your position on that?
I think that there are certainly, we have experienced some excessive awards in connection with pain and suffering. I think the reason that we've experienced those excessive awards is that the rules that we give to juries in connection with coming to what an appropriate award should be are vague, ambiguous, and don't give them much structure and guidelines. And I think we need to do something to assist them along
Do you
those
believe
lines.
do you believe in the process of the law, Harold? Do you believe in the law? You're a lawyer, and you're saying to me that you don't, in a sense, your answer says to me that you don't believe in the law.
I don't think my answer says that to you.
Well, all right, all right.
That's close to what I've said.
Harold, let me
And I think
suggest
the
to you
question in
that
and of itself is totally irrelevant.
the excessiveness of jury awards, it's dealt with in a very principled way. The way to address excessive jury awards is that the judge, has the inherent power to reduce or, by the way, increase unfair or jury awards. That's the one thing. And you do that immediately following the verdict or within 15 days, so that if it isn't supported by the evidence, the law has the curative effect there by allowing the judge. And in addition to that, as you know, we have the appellate divisions in this state for departments. If you have excessive verdict, you bring your appeal, and the appellate division sometimes does increase awards, thank heavens. More often than not, they decrease awards because they in their opinion, they're excessive. It's a check and balance system. It goes back. Let me finish. Let me finish. Wait, let me go back. Let me go back and finish. We have in the judicial system the same things that we have going back to 9th grade civics that we all learned, which is the executive, the legislative, and the judicial. We have checks and balances. Checks and balances exist in the judicial
What's the
system.
standard? What's the checks and balance when an appellate division looks at a jury award? What is the checks and balance?
What's
the standard for their review?
The standard for their review.
What the prior awards for the similar injury look like, which means we're back to what the jury originally, in other cases, awarded.
That's absolutely untrue. The standard is does it shock? Originally, the standard is does it shock the conscience of the court? The jury isn't, and the judge, the trial judge and jury is in the best position to determine what an adequate award is.
Well,
The tort system as
Harold,
it exists
let me
now
ask
is
this.
perfect. There's
Harold,
No, I'm saying
excuse me one second,
no
gentlemen,
areas of-
excuse me. Do you feel that, is it your position we're in a litigation crisis now?
Are we in the litigation crisis? To be perfectly frank, that's hyperbole. I do believe that, without question, there are some serious problems involved in the way tort litigation is handled in this country. Yes.
Okay, and how would you correct it?
Well, again, there are a number of ways you can do that. You can go by product line to specific issues like how do you deal with product liability cases, or you can deal with it in a broader context. I think one of the ways to deal with the sheer volume of tort litigation in this country is more by further use of alternative dispute resolution. I also think we have to seriously look at the volume and nature of the suits that are filed, because I do believe if we took a serious look at those cases, we would all agree there is a certain percentage of cases that are filed that are just not appropriate for
Harold,
lawsuits or the courthouse.
Wouldn't it be a fair statement that you're a profit-making institution, American International Group is a profit-making institution, and you would like to pay out less money, not more money?
That's absolutely true, but we also would like to believe that we live in a society which is governed by law and rules. The point of being in a society that's governed by law and rules to a certain degree is to assist people in predicting what will happen to them based on their behaviors. And our position is the way tort litigation is now handled in this country and the way it's evolved over time is that there's very little predictable value to it.
Well, I'm not certain that we're answering the question. I think it is very predictive. I think that that you have, I happen to think that the Holy Spirit descends when 12 good men or women, tried and true, deliberate in criminal or in civil. I think that it's a genius system. I think 6 people can find the truth, and very often do. I have to take you back to 1215, when we had a bunch of barons in the meadow at Runnymede who said to King John, "We want the right to be able to take our dispute to a jury of our peers." What are we afraid of? What is your company afraid of?
We're not afraid of anything.
You're saying that
we're trying to deal with an issue. The tort system evolves. It's built up almost as
That's right, the common law.
That's right.
The common law.
And anything that develops in a very narrow circumstance over time, when looked at as a whole, may not have the rationale, the logic, the order, the discipline that the individual case may have led one to believe.
Harold,
and as a result, it doesn't hurt to look back over time and say, well, maybe this is slightly out of balance. Maybe this isn't exactly accomplishing what we thought it would accomplish. Maybe the predictability isn't there.
Harold, you're talking about homes. You're talking about the common law. That's the genius of the common law. Every case builds on each other. Every case is, and the exceptions are taken into consideration, and it works. And then a jury, an appellate court looks at that. And if justice isn't done or there's error they have the absolute right to reverse it, send it back for a new trial, to reduce the verdict, to add to the verdict, any of those things.
And we have to take a break right now. We'll be right back with Law Line. You're watching Alan Schnorman. Stay tuned.
The air dances with the waters, which brings the rain that feeds the land, that is home to the animals, All life dances together.
In a world so connected, choosing one environmental cause can be hard. EarthShare is 40 environmental charities working together. You and your company can help by calling 1-800-MY-SHARE.
All life lives, or doesn't, together.
Excuse me. Do you wear your safety belt?
Why, no. I don't wear my safety belt.
Thank you.
You could learn a lot from a dummy. Buckle your safety belt.
There's an awesome power that can eliminate over half of our nation's defense forces. It's everywhere, and it can strike at any time. Who has this incredible power? You do. If you employ National Guard and Reserve members, you need to use your power wisely, because today, the Guard and Reserve make up over half of our country's defense. So when they need time off to serve, be a hero. Give them the freedom to protect ours.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're talking about the supposed tort crisis. Our guests are Robert Lamb, president of the New York State Trial Lawyers Association, and Harold Jacobowitz, vice president of American International Companies. Rob, right before the break, we were talking about what the situation is now in our state regarding vis-a-vis accident cases and the movement to change the system. And what is that in the legislature?
Well, the movement very definitely has been over the years, and I think we go back to the early 1970s. The movement has been to constrict the people's right to go into a court. That's what the problem has been. We had no-fault automobile legislation. 1985, we had a constriction in the medical negligence field, and recently, of course, we have the so-called workers' compensation reform. There's a movement to restrict the people going into a court and adjudicating their rights.
Let me ask you this. Isn't it true that in many counties, juries are now bringing in more defendants' verdicts?
As a matter of fact, I think that the percentage in medical negligence happens to be, when a medical negligence case goes to trial, almost 70% of those cases result in verdicts favorable to hospitals, doctors, and dentists, mainly because it is dreadfully difficult to prove a medical negligence case, and secondly, people do trust and believe in physicians, and it's a difficult burden.
Harold, what
Is the fact that doctors are winning malpractice cases an indication that too many cases aren't being filed, or cases that shouldn't be filed are being filed? I mean, the fact that they're winning is in fact maybe an indication that there's still something terribly wrong with the tort reform system. That they win that many cases, or that high a percentage of cases, may lead one to believe that maybe some cases, or too many cases that shouldn't be filed, are being filed.
The fact is, Harold, that medical negligence cases have gone down steadily, have gone down remarkably since 1985.
Harold, let me ask you something. What percentage of the cases, and I know there are thousands and thousands of cases which your company is representing insureds all over the United States, what percentage of those are settled prior to a verdict?
The overwhelming majority, probably somewhere in the range of 95%.
95%. Excuse me one second. And when do you settle the case? Do you settle the case as early as possible, or right before the verdict? When is the optimum time for your company to settle the case?
As absolutely early as possible. As
I
early as one can make a reasoned
wish I
decision.
could believe that. I think one of the big delays in this state is the fact that we do not have what we call prejudgment interest. If we had prejudgment interest, I submit that insurance companies would settle cases that are meritorious a heck of a lot sooner than they are.
There's no interest. There's no interest now
Yes, there are.
prior to a verdict.
Yes, there are. That's right. And I'm saying,
Are there
I'm
states in
saying,
the union that have
yes, there are
and
states.
And are the durations in those states less
Shorter.
than here?
Yes, they are.
And is that because they have prejudgment interest, or because they have about
It
85%
induces-
fewer cases filed?
No, that's not accurate at all. It
The simple
induces
fact of
a
the matter is
carrier.
prejudgment interest is
It
not the
induces a
issue.
carrier. Sure, it's going
And for every
Harold,
case
you're
that's
against
delayed
it
by a
because it's gonna
defendant,
cost you money.
there's a case delayed by a plaintiff. The simple fact of the matter is, he'll tell you about not being able to get something from a defendant, and I can bring in a
Harold,
host of
wait,
lawyers
wait,
that
wait, that's
they can't get a bill of
nonsense.
particulars.
That's nonsense. That's nonsense. 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 Judgment delayed. Justice delayed is justice denied. I have news for you. Any good plaintiff's lawyer doesn't delay a case because it is not to our interest to delay a case.
Because there's no
I want to
interest on the judgment.
There's no interest on the judgment, and you don't get your verdict, and your client is sitting out there in limbo. I want to bring a case in, and I'll tell you what my goal is. I want to bring a case in. I investigate it. I put it into suit. I do my depositions. I get it, my note of issue and statement of readiness filed, and I get it before the trial court as soon as I can because I want you to pay.
Why is it then that in a significant percentage, maybe 40% of the cases in any particular defendant's firm, you will have to make a motion to get a bill of particulars out of a plaintiff's firm? If
No
in
more,
fact
they've changed
they're so
the rules.
desirous of moving cases
They've changed
forward,
the rules.
why was it when I grew up as a young attorney, the first thing I learned how to do was make a motion for a bill of particulars?
And a
Why
bill of
is it-
particulars, of course, is a list of the damages and the special damages and the interest.
Right.
Let me
But
ask
if-
this.
and if a firm
What
is so
about-
eager to
what
move
about
a
the-
file, why do you have to pry that information out of them?
Give us some inside information.
Yeah, really.
How does an insurance company evaluate it? How do they come up to a certain number to offer a plaintiff? How do you come up to that number? Whether it's $10,000 or $100,000 or $150,000.
Probably in a way very similar to the way plaintiff's attorneys do it and defense attorneys do it. Obviously, the first issue is, to what extent is their party responsible for the injury?
Okay.
And then, of course, they do the best they can do to define and really understand what the injuries are and how it's affected that person, either in their work or otherwise. And then as a general proposition, like everyone else, they base it on historical experience, what that kind of injury
Do you
is
take into
valued as.
consideration where the action is brought, whether it's the Bronx or Westchester County?
That is certainly one of the factors that
Do you
would be
take into
involved.
consideration who's trying the case for the injured party?
That would be a factor, sure.
Would you offer one attorney more money than another attorney for the same exact case?
Well, it's not necessarily a question of offering them more money. The issue is, if your goal is to try to resolve the case via settlement, and you're up against an attorney that you know is one who's more likely to try a case than settle it, at times it may cost you a little bit more, although you're saving it on the ultimate defense costs to settle the case. Your ultimate payment may not be any more. It's a question of whether or not you're paying it in settlement dollars and expense dollars, or one or the other.
And when do you find is the best time for the insurance company, to settle that case most advantageous for you?
The simple fact of the matter is, the best time for any insurance company to settle a case is at the earliest point in time that they have the information available to do so.
Why don't you do it?
I think we do.
I think that certainly belies my experience. You know, I think that it is truly depends upon the lawyers. If you know that I'm trying my cases and I'm going to go in and try my cases, I have a better shot at settling a case fairly for my clients than some guy who just doesn't have a track record.
Not if you haven't given me the information we need, not if we haven't been able to get the information we need. The simple fact of the matter is, there is no question but that without the information we need to fairly evaluate a case and make a reasonable offer, there is nothing we can do.
Let me ask
The simple
you-
fact of the matter is, you can say we don't do that, but on the other hand, I can tell you, there's a whole world of
I have
places
two- I have two
who don't
questions.
accept
One
reasonable
second,
offers either.
I have two questions.
Well, excuse me one second, Bob. I've asked you when's the most opportune time to settle a case, but when do cases mostly get settled? The 95%, in your experience.
Most cases, it's hard to say 95%. Most cases settle in a litigation mode probably at the close of discovery, somewhere between the close of discovery and
the time of
selecting a
trial.
jury.
And the time of trial.
Is that what you found?
Absolutely, absolutely. If I have a case, I will certainly give a carrier an opportunity, and I will give them, and all good trial lawyers will give them, the information that they need as soon as they need it, as soon as we get it. We have an open discovery state. we give them everything, and they have that information, and you also get it through the course of the litigation. And if it's a significant case, in my experience, you guys meaning insurance carriers, don't settle until damn near being on the courthouse steps. And in the meantime, you talk about delay. Let's talk about the motions for summary judgment and the nonsense motions that you put in the way right along to delay this case.
Now, a motion of summary
Actually, it's
judgment is you're
fascinating
telling the
perspective.
court that there is no question of fact here.
That's right.
The judge can decide it just on papers.
Just on papers, right? And so you'll go through a motion for summary judgment, and then you win your motion as a plaintiff. You win your motion for summary judgment. Then the insurance carrier or defense carrier takes it up to the appellate division. So now we've delayed it for a year and a
The first
half.
comment I have to make is, we've gone from being the tort system being perfect, which obviously it is, and the only problem with the tort system, obviously, the guys who are on the defense side, they do everything wrong. The tort system itself is fine, and the plaintiff bar is doing everything right.
I'm not suggesting
The fact of the matter is, some motions for summary judgment made, motions for summary judgment are made. Are they made too often? Maybe they are. If they are made too often, then I argue this in connection with defense attorneys as well as with plaintiffs' attorneys. There should be a methodology in connection with litigation so that frivolous acts are penalized. I have no problem with that. I don't have a problem with it with plaintiffs' attorneys. I don't have a problem with it with defense attorneys. The simple fact of the matter is that's the difference between us and right now the organizations that speak for the plaintiffs' bar. The organizations that speak for the plaintiffs' bar only see it in one way, and that is the system's perfect and everything that's wrong is the defense bar. And the only things that have to be corrected on that side of the line. There is never a reasonable, rational proposal to fix anything that comes from the plaintiff's bar.
Harold is setting up a straw man. We're not suggesting that the system is perfect, but what we are suggesting is that it's the best system that we have. And what we are suggesting is that
make a suggestion that makes it even better.
Let me finish. I was courteous and let you finish. Let me finish. I'm not suggesting it's perfect, but what we're suggesting is that the tort system and the civil jury system is a vehicle for change. It gets people there. Now, let me finish.
That you think we should make? What's the change
I'll tell you what, prejudgment interest so that you come to the table.
So
that's
that
a
we come to the
legitimate
table. Right?
Yes. If we're talking about non-frivolous, if we're talking about let's settle cases that are valid, let's talk about them early, and let's put something here in place so that it gets you to the table rather than waiting for 3 years and 4 years and 5 years. Because let's face it, Harold, you keep an award of $100,000 or $1 million in your coffers, you're out investing that money. And you're making money on not settling the case or not adjudicating the case. And indeed, even when I get a verdict.
We have a minute left.
Actually, there's so much to say that I could not possibly get it in a minute.
Would you answer my question?
The fact of the matter is, prejudgment interest on the overwhelming majority of tort cases filed in this state, which is probably somewhere between $500 and $10,000, isn't going to drive anyone to anything.
When you multiply it by all of the 132 countries or states.
But the simple
that do
fact of the
business.
matter is, that's not going to solve the problem. If prejudgment interest is your response...
One of the responses,
prejudgment
in the
interest,
amount of time.
Why not alternative? Why not mediation? Why not open discovery?
We
Why
do
not-
have it.
We do.
We do.
Bob Lamb, president of the New York State Trial Lawyers Association, thank you for being our law line.
Pleasure.
Harold Jacobowitz, vice president of American International Companies, and thank you for being our law line. Certainly it was a spirited conversation, and as always, this is Alan Schnorman, and thank you
And
for
we'll go
watching
out
Law
on the
Line.
street and finish a conversation.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.